Hey everybody, John Skiba here from the Consumer Warrior Project. And today I want to give you a sneak peek into a new online video tutorial course I'm creating as it relates to using arbitration clauses in defense of a junk debt buyer lawsuit. So if you're getting sued by a junk debt buyer on an old credit card debt, companies like Midland Funding, Portfolio Recovery, Cavalry SPV, those are some of the big ones. You can actually use the arbitration clause that's found in the credit card agreement with the original creditor as a possible defense. So I'm going to have a course coming out really soon on really the nuts and bolts of this and how it works, but I wanted to give you a general overview of how that can work. So let's start off by talking about what private arbitration is. Private arbitration is essentially where the parties agree to submit their dispute to be resolved not by a court, but by a private arbitration company. Probably the largest is the American Association of Arbitrators, or the American Arbitration Association. And so you can submit your dispute to them, they will resolve it, and then the parties agree that that'll be binding upon them. It is a private company, so you are paying for it. When you go to court, you pay a filing fee, but it's frankly nothing compared to the fees that private arbitrators are going to charge you to resolve the dispute. It is dealt with much more quickly, and it's typically less expensive for the parties to deal with the case there, just because there's limited discovery and it just doesn't go on quite as long. Now, how you know if private arbitration is a possibility in your junk debt buyer lawsuit is you need to look at the credit card agreement that was issued by the original creditor. In almost every one of these, there is an arbitration clause. You can find it because it's usually in all caps and bolded because it impacts your rights as it relates to bringing any type of claim against the credit card company. But what it also typically does is it allows either party to elect to have their dispute dealt with through private arbitration. This means that if a junk debt buyer files a lawsuit against you in a local court, you can actually file a motion to dismiss the lawsuit and require the parties to attend private arbitration. Now, there's a couple approaches to this. I can tell you that a lot of times courts will dismiss it. They're generally good about getting another collection case off of their docket. So they'll dismiss the case, and then typically these arbitration clauses will require the party who has the claim, they have to be the one to actually file the lawsuit or the claim in arbitration. And so that would be the junk debt buyer, because they're the ones that are saying they have a claim against you as a consumer. They're claiming that you owe them money. So they're required to then file the arbitration through the American Arbitration Association or whoever's going to be handling it. The issue for them that you've now put them in is that it is not cheap to file a lawsuit with AAA, the American Arbitration Association. It's expensive. And in fact, for even minor, kind of relatively minor collection issues, it can cost anywhere to $1,500 up to $4,000 for them to file that lawsuit. And there's no guarantee that they're ever going to recover those funds directly from you. So that you now put the junk debt buyer in a position of whether they actually want to proceed against this or not. And again, you're just using the terms of the agreement that the original credit card company wrote. These are the terms that they wanted. These are the terms that they imposed upon you, and so you're just electing to use those. Even if they do elect to move forward with it, generally it's not going to cost as much for you as the consumer. There's generally terms in there that limit the amount of money that a consumer has to actually pay to the private arbitrator to get the dispute resolved. And then even if they do pursue it and they win, they have an arbitration award which is different than a judgment. Judgments can be used for wage garnishments, for bank levies. Private arbitration awards cannot, unless they take it through another court proceeding and get that arbitration award turned into a judgment. So there's some benefit to you to actually asking the judge to dismiss your case and have the junk debt buyer decide if they actually want to pursue this through the private arbitration process. I can tell you with a lot of cases that I deal with, I don't see that the junk debt buyers want to pursue that route just because simply it's so expensive. So I'm going to go into a lot more detail on that and give you some of the templates and forms. You can see the current courses and tutorials that I have already over at legal.coach. That's the actual website, www.legal.coach. You can go over and check out the forms and templates and tutorials we have. That one's going to be coming soon, here in the next 2 weeks, and I'll put out another video once it's ready to go. But appreciate you watching today.